Good afternoon, everyone. Welcome to this session, CCH Network's webcast on the Diverted Profits Tax, run in conjunction with the Corporate Tax Association. My name is Michelle Niese. I'm the Executive Director of the CTA, and welcome to all of our members here and across Australia. We have about 360 people beaming in to us across the nation, so welcome. To those that are online or beaming in, you will have the opportunity to ask questions. I have a laptop. Laptop's not a laptop, is it? It's an iPad. I have an iPad here which apparently will bring up the questions from the other states. They will be anonymous. I won't know who they're from. And what we'll try to do is, after the ATO have made their presentation, the ATO is going to present a semi-formal presentation for around half an hour. Anthony will pose some questions around the various products that the ATO have put out, and what I'll attempt to do while Anthony is doing that is to field the questions from both this audience and the audience across Australia. For the audience here today, we've got about 70 people in the room. We do have microphones, but for the benefit of the people not in Melbourne, I will repeat the questions from this audience so that everyone can understand what is going on. So without further ado, I'm going to introduce our presenters today. First, I'll go from this end to this end. Nick Maley on the end here. Nick is an Assistant Commissioner, Diverted Profits Tax and BEPS, so I think you might know what you're talking about today, Nick, which was helpful. Public Groups and International. Nick's been Assistant Commissioner at the ATO for a short period. Prior to that, he was at PwC. He has extensive experience in corporate tax advice and M&A transactions, and I know from chatting to Nick on and off over the past year or so, he has intimate involvement in all of the products that have been put out today, so we welcome him here. We also have Julian Roberts, Assistant Commissioner, Tax Counsel Network. Julian is also an outsider, previously at a national law firm as a senior associate, where he advised clients on tax disputes and litigation. Julian's job in the ATO is to provide technical advice on strategic and high-risk international tax matters. And finally, last but not least, Anthony Portas, Minter Ellison. I've got my two previous employers on this panel, so there you go. And both were wonderful experiences, I shall say. Anthony has more than 25 years' experience in corporate and international tax. He is now at Minter Ellison, and you've been there since?
About a year and a half.
Year and a half, lovely. Before that, Anthony was Head of Tax at Anglo American in Brisbane. And he also has previously been Chairman of the Minerals Council of Australia, and his happiest time in his career was when he was an Executive Committee member at the Corporate Tax Association. Isn't that true?
That is true.
That is true. It doesn't say that, but I know that, right?
Feel it.
Exactly. So before I kick off, I thought I'd just note for everybody in the audience that there is a fairly large, not a large in terms of page numbers, but a joint submission that is underway at the moment. That's being lodged tomorrow. At this point, we have the following people signing that joint submission on the Diverted Profits Tax. The CTA, Deloitte, Greenwoods and Freehills, KPMG, the Law Council, Tax Institute, EY, and CANS. So it's been a interesting process to get everyone on board, but that gives you an indication of the level of interest in having strong guidance on this matter. So without further ado, I will hand over to the Tax Office. Thank you.
I thought I might quickly start with a quick overview of the law just to catch everybody up. We'll then go through some of the guidance products that we've been dealing with, particularly focusing on the PCG that everybody's been focusing on and really are the key points that we want to discuss today. But I think it's important to take a step back and go through some of the key technical issues, the DPT, apologise for that boom, that we need to consider when we are dealing with this. So it works, that's the first step. So, starting with the overview, I thought it's always important, and from the questions that we do receive when we are discussing DPT, I think it's always important to restate the objectives in here. So this is a direct replication of the objectives that are actually in the law, and we see here that the real purpose of the DPT, the first one is that it's really by significant global entities to reflect the economic substance of their activities in Australia. There's a couple of tests here that are unique to DPT that really focus on this point. To prevent those entities from reducing the amount of Australian tax they pay by diverting profits through contrived arrangements between related parties. So it really shows what we are focusing on here, that it's really related parties. We need a related party transaction to trigger the DPT. And thirdly, to encourage those entities to provide sufficient information to the Commissioner in a timely manner. I've quoted my boss there. It's always good to quote your boss. So I've quoted my boss there. This is pre the DPT. This is pre the DPT being envisaged, but it really goes to what we're talking about here. That there are a very, very minute number of taxpayers that really try and game us, that really try and play the games, that really try and slow it down. So we're focused on here that we'll be reasonable with those that generally cooperate, but take a much harder approach on those that don't. And the DPT is one of those measures that is along those lines, that if it applies to only a very small number of taxpayers. You've got to get through a bunch of thresholds for DPT to apply, but if it does, it really penalise with a penalty rate and some of the change in rules around evidence. It really does encourage taxpayers to deal with the tax office. So I've got a little breadcrumb here that goes through the key elements that you require for DPT. It's in the Part 4A, so it's in our anti-avoidance provisions. It's a 40% rate of tax and applies to income years commencing on or after 1 July 2017. But important to note, the scheme can be entered into prior to that period. So we need the tax benefit to arise in an income year commencing on or after 1 July 17. About 40% of the population that DPT can apply to have a 30 June year end, so about 40% DPT was relevant to from 1 July. The remainder up until 1 January this year to kick off. So significant global entity, this is not unique to DPT, it's consistent there, but broadly for the purpose of this, we need a global income of $1 billion turnover. It relies upon accounting consolidation principles, so there are some taxpayers that will fall out of those rules or be picked up. So there's a little bit of nuance there, but broadly $1 billion turnover in your global group. Secondly, we need a scheme. This is an existing concept in Part 4A. There's not really anything new for DPT. So really this is something that we haven't sought to put much guidance on, because this is something that Part 4A has been considering for extended periods of time, and so the jurisprudence is there. We haven't sought to put additional guidance on. Similarly, tax benefit the DPT relies upon the Part 4A concept of tax benefit. We need to consider a counterfactual and work out what tax benefit that Australia has obtained. Important to note for DPT, the tax benefit can be an Australian tax benefit or an Australian tax benefit and a reduction in foreign tax. So this really goes to, you need a principal purpose of obtaining a tax benefit or a tax benefit and reducing a foreign tax to pick up those schemes that Australia is but one of the many countries that the taxpayer is really looking to avoid tax. It has been suggested in some submissions that the sole dominant purpose test in Part 4A cannot apply because the sole dominant purpose was to avoid a UK tax, a German tax, and Australia was just one of the smaller taxes that also followed along. So this would overcome that hurdle. So Australia and a reduction in foreign tax means that we can look at schemes that Australia is one of the jurisdictions that there is a tax avoidance scheme involved in. And this is similar to the Maley concept of tax benefit for including a foreign reduction in tax. And then we've got the principal purpose test. So we need a principal purpose of obtaining this tax benefit. We've got a couple of discussion points that we'll discuss on this today in a bit more detail. But this is similar to the Maley, and we've outlined in the Maley LCG what the ATO's view of principal purpose is. Unlike Part 4A, where there's years of jurisprudence, there's not much jurisprudence on principal purpose test, but it's becoming more and more common. So the Maley used it, DPT used it, and now the treaty abuse provisions in the multilateral instrument that's coming shortly also picks on the principal purpose test, as opposed to sole dominant purpose in regular Part 4A or the A purpose but not incidental purpose in 177 EA. Then we come to the exceptions. These exceptions are all actually unique to DPT, and we've spent a bit of time on some of these in our guidance products to date to really hone in on some of the nuances that we want to focus on, or give some guidance as to how taxpayers can meet these tests. The 25 million test is 25 million of income in Australia. So if you're below 25 million of income in Australia, then DPT doesn't apply to you. Really just a de minimis to remove those taxpayers that are very low risk due to the sheer size of their operations in Australia. When we looked at pulling together some of the pricing for Treasury on what this would look like when DPT was coming in, taxpayers that were part of a SGE, so $1 billion turnover, and had more than $25 million turnover, represented 85% of all cross-border relationships, all by value, of Australia. So really this de minimis removes those ones that are quite small, quite low risk. Importantly to note, it also includes any diversion of profit. So if you're below 25 million, but that's because you're not including the profit in Australia, that you're receiving a tax benefit by not including some income in Australia, then that would also be picked up. So you wouldn't be able to avoid the operation of the diverted profits tax by diverting the profit out of Australia, such that you blow this threshold. Then we move to sufficient foreign tax test. Broadly, DPT will not apply to you if the total increase in foreign tax liabilities is 80% of the tax that you otherwise would have paid in Australia. This is not the headline rate. We can't just merely go and say, well, New Zealand rate's at 29% or 28%, Japanese rates, whatever it is. We need to look at what tax is actually paid on the other side of the scheme, or there is a liability to pay it at some point in the future. This is important. There are some jurisdictions that whilst have a high headline rate, have patent box regime, losses, credits, exemptions, other scenarios that result in no tax being paid on the other side of a transaction. We used to use the US as an example in our internal training, but they went and reduced their rate anyway, so it's probably a bit of a moot point. But the US had very concessional rules on amortisation of goodwill, amortisation of other IP, the result of which meant that whilst there was a payment to the US, there was actually no net tax, or through the use of their elections to regard or disregard an entity, it resulted in, whilst there was a payment to the US, no actual income pickup and no tax paid in the US. So there are scenarios where this is something that's quite easy to show, that you have tax on the other side. We've been dealing with a few taxpayers that have APAs, especially with some high tax jurisdictions, that it's very easy to show they're paying tax on the other side. But it's actually a requirement to pay the tax rather than just have a high headline rate. Then we move to sufficient economic substance. So again, if you have sufficient economic substance in your scheme, the DPT can't apply. That doesn't mean transfer pricing or the regular Part 4A or other provisions cannot apply. It restricts the ability for DPT to apply to you. Sufficient economic substance being unique to DPT and being one of the objectives, the first objective that was set out in there, we've really focused on that in part of our PCG. So all the examples that are currently in our PCG are high and low risk for sufficient economic test alone. So this is really a new area that we wanted to give some guidance on as to what we consider sufficient economic substance to be. And importantly, it's going to be very different depending on what industry you're in, what arrangement you're undertaking, what the relations are between the entities in the scheme. So we've sought in the PCG to outline high risk and low risk examples to really frame up some of the things that we are looking at, some of the things we're concerned with, and equally some of those that we're not concerned with, and some of those that we're comfortable that you can give yourself a low risk rating and move on. Sufficient economic substance test requires that the profit made by each entity in the scheme reflects the economic substance of that entity's activities. So there's a profit test. For the most part, that is actually something that would be beneficial. The insurance industry is a little bit more difficult. So the insurance example in there, we've really focused on some of the things, but when we look at what that means for insurance, the profit can be actually quite difficult to show when it comes to substance. So we're working on some tailoring of that example to really tighten that up, to give some certainty there. But for the most part, the profit made by each entity needs to reflect its substance. Beg your pardon. It's each entity in the scheme, so obviously this would require identification of the scheme. Our examples in the SES part of the PCG are relatively straightforward in identifying what taxpayers are relevant. In practice, this may be a little bit more difficult, and it requires analysis of what each entity is contributing to the scheme and what the relative profit is for each of those entities. Before I move on to the next page, just want to mention sufficient foreign tax as well. It's sufficient foreign tax in connection with the scheme, but it includes those entities that are otherwise connected with the scheme. They might not be directly party to, but they're otherwise connected with. And this really looks at those sort of flow-through entities where you've got a trust or a partnership that there's party to the scheme, and the trust or the partners end up paying the tax. So long as they're otherwise connected with the scheme, then we can look at their tax to give the comfort that DPT won't apply. I might hand to Julian to discuss the administrative framework.
Thanks, Nick. The administrative framework that you see on this slide is set out in our DPT practice statement, which is PSLA 2017-2, which was released late last year. I'll just jump forward. So the PSLA sets out the steps that our officers have to take in order to make a DPT assessment, and then after a DPT assessment is made. Practice statement differs from our practice statement on what I'll call classic Part 4A, and it was developed in recognition of the seriousness of making a DPT assessment. You can expect it to be followed in all but exceptional cases. The starting point under the PSLA is that in order to commence a DPT review, an officer has to first obtain approval from the DPT specialist team and engage TCN. Now, I think you all know who TCN is. The DPT specialist team is a new team within the tax office that was established to manage DPT cases. The team is headed by Nick Maley, my co-presenter, and includes a number of directors and other officers with international experience. And the team reports to Deputy Commissioner Mark Conser, who's the head of our international division.
What's the size of it at the moment?
13 people. So we've got 13 people that are in that specialist team. And a lot of the size is driven by the sort of internal training and the internal size that we're doing. Obviously that doesn't include people like Julian that come from a technical area and provide technical assistance, and it doesn't include the people that write our PCGs that also come from Julian's area as well. So at this stage it will shrink a little bit into the next year to reflect that we're not doing internal training at the tax office after that period, but should be about 10 people on a go-forward basis.
So once a case is approved by the DPT specialist team, a DPT review proceeds in the usual way, although the specialist team and TCN are thereafter involved at all stages. Assuming that it then goes this far, there are then 3 additional steps that have to be followed before a DPT assessment is issued, and they are first that the team has to obtain endorsement from a DPT review committee. The DPT Review Committee consists of the Assistant Commissioner from the DPT Specialist Team, an Assistant Commissioner from the Case Team's business line, and an officer from TCN who, as often as not, will also be an Assistant Commissioner. The second thing is that the team has to refer the case to the GAR Panel for an initial hearing, and the third thing is that they have to obtain endorsement from a Deputy Commissioner from their business line. Before moving on, I should just mention a few things about the GAR panel. The panel is made up of some very senior tax office people, along with 3 or 4 external members. One of the external members is usually a retired judge, and the others tend to be very highly regarded external practitioners. The basic function of the panel is to provide quality control. Believe it or not, the tax office is not interested in losing Part 4A cases in court unnecessarily, and if our case isn't good, we want to find out before we actually get to court, and that's where the panel comes in as a sort of discipline that we impose on ourselves. The panel provides advice to the case team, who is and the advice goes to whether the application of Part 4A would be appropriate, not whether it would be correct, and the case officer or decision maker can depart from it if they choose to. But I should say that it is strongly influential advice, and that I can't possibly overstate that. I think if the decision maker wants to apply to Part 4A despite contrary advice from the panel, you have to go and get approval from the most senior officers in the organisation, being the Commissioner, a Second Commissioner, the Chief Tax Counsel, or the Chair of the GAR Panel. Those of you who were listening closely will have noticed that I referred to an initial GAR Panel hearing. This is different to our current process for normal Part 4A, which involves the option, it's not actually a requirement, of a preliminary hearing. A preliminary hearing is really just a vehicle for the case team to approach the panel to get some preliminary advice on whether they're on the right track and what to look at in audit. Whereas an initial hearing for the DPT is a bit more than that, because we recognise that a decision to issue a DPT assessment has very serious consequences. For one thing, tax becomes due and payable after 21 days, and at the moment our intention is to make the taxpayer pay it, so there won't be any tax deferral arrangements. So the point of the initial hearing at the GAR Panel is really to get assurance at this stage that issuing a DPT assessment would be appropriate before it's actually issued. And while there's a further GAR Panel hearing, in the period of review, I think it's fair to say that you can expect a very high standard at this stage. The practice statement also sets out what happens after a DPT assessment is made during the 12-month period of review. And the most important thing, I think, the next steps are listed there on the slide, but probably the most important thing is, as I've said, there's a further GAR Panel hearing, and it will generally happen towards the end of the review period once all of the information has been obtained. And at that point, a taxpayer will have an opportunity to present its case to the panel, which usually means having the freedom to say whatever you want over a 60 to 90 minute period. Although the panel members invariably interject to tease out the critical issues. Generally, at a GAR Panel hearing, it's the facts that matter because the panel tend to know the law, and what matters most is to clearly articulate the facts and the wider commercial context, and all other things being equal, taxpayers who usually do that tend to fare the best, at least in my experience. The one other thing to note about the practice statement is that it doesn't actually deal with what happens after the review period, and that's quite deliberate. At the end of the review period, as you'll see there, if the matter hasn't been resolved, the taxpayer can appeal to the federal court, and the matter's then in the court's hands. At that point, the only thing really left for the Commissioner to do, other than prepare his case, is to consent to or decline to consent to the admission of any restricted DPT evidence. By restricted DPT evidence, it's not actually mentioned there, but it is mentioned back on the administrative framework slide that is now up on the screen. The restricted DPT evidence rule refers to the fact that in an appeal, the DPT provisions operate in a way that precludes the taxpayer from adducing evidence that was available to it but not the Commissioner during the period of review. So it's probably fairly obvious that there's nothing else like this in Part 4A, and in fact the only thing like it, or that even resembles it in the tax law, would be Section 264A. The offshore information gathering provision, although the obvious distinction with that provision is that 264A merely prevents a taxpayer from using evidence that has been requested by the Commissioner but then not provided, whereas the restricted DPT evidence rule goes a bit further than that and essentially limits the taxpayer to the information and documents that were actually provided to the Commissioner. I think probably evidently the point of the restricted DPT evidence rule is to force the taxpayer to either disclose evidence relevant to the operation of the DPT or forgo its use. And it's probably the part of the law, in my opinion at least, that I think will promote the timely resolution of tax disputes, which Nick mentioned was one of the objects in section 177H. While it won't completely fix the problem that we sometimes get of uncooperative taxpayers cherry-picking evidence, what it should do at least is leave us in a position where at the end of the review period we can assess the case based on the evidence that's before us with a fair degree of certainty that wholly new evidence won't be placed before the court except in limited circumstances. So I suppose it levels the playing field in that sense. As to whether the Commissioner will consent to the admission of restricted DPT evidence, I can't really say much about that, and I imagine that it's something that will be decided on a case-by-case basis. There are probably very clear instances in which consent will be given. For example, I can't imagine the Commissioner would withhold consent where the case against the taxpayer changes fundamentally from what was put to the taxpayer during the period of review, or where a wholly new point becomes relevant that the existing evidence doesn't actually illuminate. On the other hand, the simple fact that the taxpayer has responded to the Commissioner's request for information doesn't mean that consent will be given to allow other stuff in. So I'll just skip forward again. The other guidance product that I want to say a few things about is our Law Companion Guideline, which is LCG 2017 D7. The draft LCG sets out our view on how the law applies. It's an interpretive product. The relevant parts of it are a binding public ruling, which means you can rely on it in good faith, and it deals with a number of things, including the purpose test, the new factors, the tax benefit modifications, and the sufficient foreign tax test. But probably the most interesting and novel part of the LCG, and indeed the new law, is the stuff on the sufficient economic substance test. The SAS test, as we call it, and as Nick mentioned, is whether the profit of an entity reasonably reflects the economic substance of the entity's activities in connection with the scheme. So the first thing you'll notice about the SAS test is that it isn't overtly a transfer pricing test. It doesn't actually mention the arm's length principle or transfer pricing or any other particular benchmark for reasonable reflection. The only link to transfer pricing is that we're required to have regard to functions, assets and risks, and also the OECD guidelines on TP to the extent they're relevant. So there are two new concepts in the test, economic substance and reasonable reflection, and there's this sort of link to transfer pricing. The concept of economic substance isn't widely used in the law. There are limited references to it in the debt equity rules, although not in the operative provisions, and I'm also told that it appears in the definition of securities lending arrangement in the Corps Act. In the draft LCG, we take the view that economic substance describes, and I quote this, the economic reality or essence of the relevant activities. It is determined by examining all of the relevant facts and circumstances, such as the conduct of the parties, the economic and commercial context of the relevant activities, and the object and the effect of those activities from a practical and business point of view. The second new concept, reasonable reflection, is used in the same asset rollover provisions, but clearly in a very different sense. In the draft LCG, we take the view that reasonable reflection is something akin to a reasonable reward. So, in other words, the profit will reasonably reflect the economic substance of an entity's activities to the extent that they represent a reasonable reward for those activities. The point that I'd probably make about the SAS test is that whatever the precise legal boundaries of the test may be, and by that I mean whether it's strictly By that I mean whether it's strictly transfer pricing or not, and I doubt we'll probably get an answer to that unless we end up in court one day. Our view of the test and the new concepts that I've just described would be fairly close to what I'd call a pretty conventional transfer pricing analysis. And it's a variation on that theme at least. Look, I expect there'll be a few questions about the SAS test, so I'll finish there. Public consultation has now ended on the draft LCG, although I think we're awaiting a couple of final submissions, and I expect that we'll issue a final version once we've fully considered all the comments that we've received. I'll just hand back to Nick now.
Thanks, Julian. And in keeping with our new naming change, once it gets released in final, it'll actually be called the Law Companion Ruling. So our guidelines will be changed names to ruling to make that clear that they are actually the same sort of level of how do I put this? Right, as other rulings. So. One thing I would like to touch on quickly on the LCG before I focus on the PCG is to go in a little bit more detail on the sufficient foreign tax test. It's intended to cover taxes that are substantially equivalent to the Australian income tax. In the LCG, we give reference to another guideline that we have at the tax office where we actually pick through some of the foreign taxes and say what we'd look for to confirm whether it's similar to or akin to an income tax. It also gives some examples there. We're looking at federal but also subnational, say state or provincial income taxes as well will get picked up. So it doesn't just have to be the federal tax, but it's specifically designed to exclude turnover taxes or whatever name they call your local tax, what do they call them, your council rates. Those kind of taxes are specifically excluded because they're not income taxes. It requires it's a legal enforceable obligation to pay. Given there's a timing here, it's important that the part that says that may reasonably be expected to arise at some point in the future. If we were to look at the Australian income tax and sort of assuming that a foreign jurisdiction has a similar approach there, the income tax, the ultimate liability that you have for your period may arise after the end of the income period. Your trigger to the actual tax being due is it's due the first day of 5 months after the income period, and it crystallises after the end of the income year. So it's these kind of things to take into account that we would look to say, well, that relates to the income period. It's reasonably that it will become enforceable once the end of the income year arises. So in relation to that income period, we would look at that tax and say that tax is picked up in the sufficient foreign tax test. But it's a legally enforceable obligation to pay. There are instances where the tax is merely an initial withhold and then refunded at some later stage, and we would look to see what the net outcome is after that the refund. Importantly, we would also look at where there is a single taxpayer, so the head of a consolidated group, if other jurisdictions have the similar concept of consolidation that we do, or where the members of the entity, so as I mentioned earlier, the beneficiaries, unit holders, similar in a trust, or the partners in a partnership, if they're connected with the scheme, the tax that they have to pay in relation to the scheme income, we would look to pick that up as well. All right, so focusing on the practical compliance guidelines. There's a couple of key points that we tried to get through with the practical compliance guidelines. One is our actual compliance approach, how we will actually engage, what avenues there are to get certainty, what we will look for and what we look to. The high and low risk examples, or scenarios, I beg your pardon, as they're referred to, they really are around the sufficient economic substance test. So those examples are specific to that area and really do only consider that. There could be more to those examples. If we tried to make it cover every aspect of DPT and all the other considerations we must do, they became a bit unwieldy and miss what we're trying to achieve. So those SES examples are solely to look at, are you high or low risk for sufficient economic substance? We are looking to include additional examples, but these were the ones that we wanted to get out for public comment as soon as we could. In addition, there's some framing questions for assessing risk, and these are the kind of things that we are advising our officers to look for when they're considering DPT risk and the various aspects of DPT. And in addition, the documentation around those relevant risks are some of the things that we'll be looking at. And finally, as I mentioned, the real key is what avenues can you get certainty, and when we will engage with you as well on the DPT. So absent a forward-looking engagement product, so an APA or a ruling, ordinarily it will be after lodgement, so post-lodgement engagement. We don't have, and I'm not sure if Anthony was getting to this on his question on the size of the team, but we don't have the resources in our team to sit down and go through cases just to look at DPT. So on a post-lodgement engagement, it'll be a regular case team considering all the aspects of a taxpayer that will consider it, and if they identify DPT, then it gets escalated to us. So we don't have the MAL where there's a set group of taxpayers that we ask to come in. We have MAL dedicated teams. Because DPT being an anti-avoidance provision, we wait for the case teams to identify it and bring it to us for post-lodgement. Once the risk is identified, it really comes down to how big of the risk is it, what are the other mitigating factors, can this be solved in some other way? So we've outlined in the PCG what our approach would be. We have encouraged some taxpayers where we've seen some DPT to consider whether an APA is an appropriate avenue to get certainty. DPT wasn't the only issue that was being considered. Transfer pricing was being considered as well, and this will give certainty to both DPT and transfer pricing on a go forward. And I've dedicated a whole slide to the APA program. This is the sort of our key focus for DPT. You can obtain a private binding ruling in relation to DPT under those factors that we would normally consider for Part 4A, as set out in our PCG. So the usual factors of principal purpose, tax benefits scheme, and the like. Where the focus has been is on the APA program, and we've got a clause. I'm not sure if anyone's dealt with it yet, but we'll insert a clause in an APA that will say we will not issue a DPT assessment for the period of the APA. And it's a will not, it's not a risk rating, it's an absolute. In relation to the covered transactions, in relation to the usual requirements that you comply with the APA, where you comply with the APA, we won't issue a DPT assessment in relation to those arrangements. It's a reflection of one, we wanted to give certainty to taxpayers, but secondly, it's a reflection of how involved the APA programs have become, especially over the past, say, 4 or 5 years. And what we're looking at is that the amount of work that we do in relation to those, then we will be comfortable for that period that we don't have a tax benefit that will give you the comfort in relation to DPT. For most of the APAs that we've been dealing with, that we look at, we're involved in, or my team or myself are involved in the initial triage. For most cases, we look at it and we're of the view that as soon as the transfer pricing's fine, we don't care from DPT perspective. So we'll tell the team that they'll go away and negotiate the usual transfer pricing outcomes under the APA, and we will wait until the very end until it's presented to us, and we will provide them the clause sign-off that they can include the clause into the APA. So for the most part, for the significant majority of APAs, we are not involved with at all. We will look at it in the initial phase to ensure that there's no concerns that we have with from DPT, and then it'll just be up to the regular case team to work through the APA under the usual program. So we're hoping that will mean that for most APAs there's no additional work. There's already a significant amount of work in APA. We don't want to add another framework, add another layer to it. So for the most part, we're not actually involved from DPT perspective, except to sign off to the case team that we're comfortable and they can include the clause in the APA. Some of the APAs that have been presented to us that we've got concerns with DPT, it's not just a DPT issue, there's many issues that there's sort of concern with, and so we're staying closer to it and working with the case team to see what the outcomes are, and if we can get an appropriate resolution that everybody's happy with, but they're again in the minority. Before I move on, we've also mentioned in the PCG some of the safe harbours, so around the financing and marketing hubs PCGs. What we are hoping to do is, as other PCGs come out in relation to other areas that give low risk rating, green zones, white zones, however they refer to them, that we can equally include that in our DPT PCG to give that same low risk rating, so to follow that, so that you know that if you're in the green zone or the low risk zone in those PCGs for that arrangement, similarly under that fact pattern you'll also be low risk for DPT. So we're trying as much as possible. Some of those will just go into the actual PCG in relation to that document, and some will be an update to the DPT PCG. But as more and more PCGs come out, that is our intention for those as well. And I've listed there links to the resources, so hopefully they work on your slides to click through to the various resources that we have on the DPT on our website and the law websites as well. All right, I'll pause here and hand over to questions. I believe Michelle's going to chair the questions.
Absolutely. I'll hand over to Anthony because Anthony's got a long list of questions to ask, and from there, if we have any questions from the audience, we'll build those into the discussion. So, Anthony.
Yes, I think how this will work best is if people get involved, and so we haven't had a practice run or anything like this. We've just talked about a bunch of issues. Some of them have been touched on in the presentation. Some of them we'll draw out here. Some of them you'll hear my views on. Some of them you'll hear the ATO, and a lot of them you'll probably, we both won't know the answer. In terms of just jumping back a little bit and talking about a bit of history, I guess I've been involved in the DPT since there was a confidential consultation on the exposure draft, which I think started in the back end of 2016. And it's remarkable that some of the issues that were being raised then in the draft consultation, or the exposure draft and the consultation on that, are still issues that we're talking about now. Now, there may well be a reason for that, and it may be that the advisor community just can't let go of some of these issues, despite the government or the tax office being very clear on them. Others, I think, the government has been clear on, and the ATO perhaps has been less clear on. So I think we'll draw out some of those points. Michelle mentioned a joint submission, which, as Nick said, there are a few submissions still to come in. One is the big joint one that Michelle raised. I've been involved in that, and I've had a look at the most recent draft of that, and I think a lot of the points that are raised in that joint submission will get raised today, and we'll try to draw them out and have some discussion about those as well. None of the points I think will be a surprise to the ATO team, because there has been a fair bit of back and forth between particularly you guys and your teams and the advisor community on the consultation, particularly around the PCG, but also the LCR and the PSLA before that. So there's sort of some introductory comments. Maybe we can start with a discussion about the PSLA. I mean, the PSLA is primarily administrative document, and it sets out what happens when within the ATO and at what points the ATO or taxpayers have involvement with the ATO on a DPT matter. And I think maybe for you, Julian, to start with, when you look at that timeline that we had up, there's two opportunities to go to for the GAR panel to be involved. My recollection, and one of those is before you get a DPT assessment, and one of them's after, in the 12-month consultation period. My recollection, and I could be wrong on this, Julian, but the first GAR panel, taxpayers aren't allowed to present at or put a representative at. Is that right? Or
That's right.
Okay.
And taxpayers are not invited to the initial GAR panel hearing.
And so maybe we just flesh that out a little bit, because, I mean, I think everyone would agree it's quite a significant event for a big corporate to get a DPT assessment. It's basically an anti-avoidance assessment. It's got a lot of ramifications, certainly at an executive level, often at a board level, and it perhaps even as a shareholder level, and the wider community, because it ends up on the front page of the Fin Review. And I guess one of the questions I have is, wouldn't it make sense for the taxpayer to be given the opportunity to present and discuss with the GAR panel, because the GAR panel is one of the last steps before the ATO then says, okay, we can issue one of these assessments, which are fairly significant things. What's the logic for not allowing taxpayers to engage or be represented at that GAR panel prior to assessment versus the panel after the assessment?
Well, I think it probably goes to one of the underlying objects of the DPT, which will be present in a number of cases, albeit admittedly perhaps not all cases, which is that the DPT, I think, was designed to operate as a kind of default assessment mechanism to deal with uncooperative taxpayers. You know, even though when you look at the actual law, that concept isn't spelled out. So I think the decision around when a taxpayer would have an opportunity to present to the GAR panel was made against that background. And I think the decision was made that at the stage before a DPT assessment is issued, that it should be for the case team and the panel, and then that the taxpayer would have an opportunity to present its case to the panel during the review period once it had provided to the tax office all of the evidence that it intended to rely upon.
And I think that context is really important, because if that were the way the subsequent PCG draft was drafted, that it was very much more focused on uncooperative taxpayers, recalcitrant taxpayers just refused to provide the information they've been requested many times. I think generally the taxpayer community that work in this space would be a lot more understanding. I think, and we'll start fleshing this out in a moment, the way the PCG has sort of subsequently been drafted is leaving people with the draft PCG, leaving people with the impression that perhaps it's a lot easier for DPT to become an issue than perhaps people were thinking, because I think you're right, in the early stages, and I think even the EM for the legislation bears this out, it was a lot more focused on contrived arrangements, focused on uncooperative taxpayers, really trying to bring them to bear, whereas some of the issues we'll talk about in a moment, it's less than clear that that's where it's ended up as a I guess from an administrative point of view, and how the ATO is going to administer the DPT. So maybe we park that point and come back to it, because I think I certainly understand it from the explanation you've given. I guess the question I have is that how it's actually going to be administered? And if the DPT is something that's going to apply a lot more broadly in a lot more transfer pricing disputes than perhaps taxpayers thought of, then that process, the administrative process, needs to be thought through, because there will be a lot of very cooperative taxpayers that just end up in disputes because there's a disagreement as to the application of the law, and it seems probably unfair, if you like, for them not to be given an opportunity to present before a DPT assessment lands. So,
so I think there are probably two things at play here. The first is what I'll call the uncooperative taxpayer situation, and the second is that the DPT can also operate in relation to aggressive tax schemes, and whether or not you're being cooperative won't help you if you've got an aggressive tax scheme. So in other words, the DPT can still apply to schemes that kind of tick the box on the statutory requirements.
Yeah, or maybe we get into the issue that I think drives this. And when you read the explanatory memorandum, there's a paragraph 1.18 which states that the DPT is expected to be applied in very limited circumstances and only after the ordinary TP rules have been given due consideration. And I think that, again, if that's the way the law was to be administered, I guess there'd be a fair bit of sympathy for the timeline that's been put, or the process that's been put in the PSLA. But again, reading the PCG as a draft document, it was less than clear that the DPT was going to be not necessarily an avenue of last resort, but was going to be something that was thought about after basically a transfer pricing dispute gets so intractable that, okay, the parties aren't going to agree on this, and there's some other aspects of the arrangement that cause the ATO concern. And I think, again, it's not completely clear from reading the draft PCG, but what I took away from reading it was that it's not at all clear when a dispute is purely a transfer pricing dispute or something that's going to have to be looked at through the lens of diverted profits tax. And so maybe we have a bit of discussion about that and where that dividing line is, because the reality of life for anyone that works in a big corporate is you will end up in discussion and debate about cross-border transactions with tax authorities, not just Australia but in other countries as well, because it's not a science. There's a lot of grey area in transfer pricing, and I think, and you'll see this when you get the joint submission, a lot of the concern that the taxpayer community has is not being able to know what the dividing line between a genuine dispute over transfer pricing, which should go down one route, and something that is going to be the focus of a DPT. So maybe just a few observations on that.
Yeah, sure. Look, it's probably best to acknowledge that we do seem to be getting this question a bit, and this issue seems to be causing a bit of anxiety, although probably unnecessarily, I think. Probably the easiest answer I can give about the distinction between a straight transfer pricing case and one where the DPT is also in play is that transfer pricing doesn't require a tax avoidance purpose, whereas the DPT does. So I think the distinction lies almost entirely in that fact. Just to elaborate on that or unpack it a bit, because the DPT requires a principal purpose, I think it's unlikely that the DPT will be pursued in what I'll call simple or run-of-the-mill transfer pricing cases. I expect its use to be largely confined to more aggressive transfer pricing cases and to, of course, the uncooperative taxpayer cases where we're having trouble obtaining sufficient information to even kind of get a handle on the matter and properly assess things. So that would include especially, I think, cases where the transaction doesn't reflect what independent parties would have done in the circumstances. So I'll loosely call that reconstruction annihilation type cases, or where the agreements don't actually reflect what's genuinely happening on the ground, which I'll again loosely refer to as the substance cases. And I suppose because it is an area of concern, it's just important, I think, to probably labour this point for a moment. We see an awful lot of transfer pricing cases at the tax office. I mean, if you walked around the PGI area in the ATO, you'd see that a vast majority of the cases would be transfer pricing cases. But I expect that only a very limited number of those will ever receive any attention from a DPT point of view. And I say that because I want to dispel this idea, which I think is popular among some practitioners at the moment, that the DPT will be applied to practically every transfer pricing case we've got. I just don't think that that's at all realistic in light of the purpose requirement.
I think we might be somewhere in the middle. But
Yeah.
Go on.
And you know, as to the purpose requirement, I suppose there's also a view that I think is linked to this concern around, well, when does transfer pricing apply and when does the DPT apply? There's this concern that the purpose test has somehow really lowered the threshold, and you know, to be frank, we just don't really agree with that.
To be fair, I think some of those comments on primary purpose are coming out of what was said in the Maley guidance document, and maybe people are misreading that. It's not a lot of, I mean, there's only a couple of paragraphs there, but I think what you said is absolutely right. I mean, I've dealt with a lot of the advisors on this issue, and I think the genuine feeling is that primary purpose or a primary purpose, it's that, is so low that most people are assuming, okay, we may have a problem with primary purpose because any large multinational is, you know, should be considering tax as part of a suite of other commercial issues they think about in any cross-border transaction. And so I think where people jump automatically is we may not pass the primary purpose test, and partly that may be because people don't understand whether it's a really low bar or just a medium bar. But then most people move into the area we're probably going to move into shortly, which is going, well, let's have a look at those three main exclusions and if any of those could apply. But I think there is a genuine concern that that bar is really, really low, and some of that concern has stemmed from the fairly limited guidance that the ATO's put out in respect of the PE avoidance. And so maybe that's something that needs to be thought through, because I think a lot of people would take a lot more comfort knowing that actually we don't even have to think about all those exclusions. We don't trip over this primary purpose test. But most people's starting point is assume you're probably going to trip over that because it's such a low bar. And now maybe in the advisor community and the big corporate community, we're all wrong on that. We're being paranoid, but I can tell you that is a genuine concern of all the people I've spoken to.
I think
Yeah.
there's an important point here, Julian, and just picking up on your point of this, I guess, significant variation between the ATO's view of how often the DPT will actually be applied as opposed to the external concerns around how often it will be applied. And I think a lot of that is not at the DPT assessment stage, it's more about when a gnarly transfer pricing dispute is ongoing and at what point the DPT will be raised or used as leverage in terms of that dispute being settled. So Mark Conser raised an interesting point at our strategy meeting a couple of weeks ago, which gave me a little bit of comfort. I'll be interested, it's your boss's comments, so I'm interested in what your view is. But he and I hadn't thought of it in this sense. So this is in relation to the PSLA. So the PSLA, obviously no one can question the strength of the guardrails in terms of assessment. I agree with Anthony. I can't really see the reasoning behind why you wouldn't have a taxpayer involved at that initial GAR panel meeting. However, that issue has been raised many times, and we've lost that argument. The other observation I just make on that point is whether or not, and I'll allow you to answer this question once I've finished my second one, whether the externals on the GAR panel will be looked at in terms of their experience, because GAR panel externals traditionally have had quite specific kind of experience, whereas you're going to be looking at transfer pricing cases here, and as we know, it's a bit of a dark art, so interested in your views on that. The point that was raised by Mark Conser was around this sort of leverage aspect and the DPT being used in the context of transfer pricing disputes. And what he said to us was, well, a tax officer can't threaten something that they don't have permission to do. And what he meant by that was a tax officer in a case team has to seek approval from your team, Nick, in order to even start a DPT analysis, is my understanding from reading that PSLA. And in most circumstances, other than those where I would assume you've got a recalcitrant taxpayer, that would mean that a taxpayer is aware from the outset, before a DPT analysis has even started, that the ATO is looking at the DPT. So that gave me a little bit of comfort in terms of at least you know that they are following those channels, and it's just not being raised willy-nilly in terms of, you know, if this isn't settled the way we want it to be, we will raise a DPT.
So the missing piece of that puzzle for me is a bit of a timeline as to how far down a TP discussion, dispute, engagement do you go before it is appropriate for the ATO to start talking even internally about DPT, because Julian gave some good examples of where you'd expect it to happen early, but in your run-of-the-mill transfer pricing dispute where we're fighting over functions, assets, risks, pricing, etc., I would have thought you would have to get a fair way down a dispute before there should even be much internal discussion about a DPT. And I know it's early days, Nick, so there's not much you can say about it, but again, these are the things that I can assure you people are getting a little bit agitated over, whether it's the advisors or the big corporates.
Sure. Can I jump in on that question before I hand to Julian for the panel question, if that's fine? So the PSLA, we try to capture this to enable us to enable a case officer to mention to a client that we're considering DPT, it needs to go to the panel, myself, normally Julian, and the assistant commissioner of their area, and that's before they can even mention it. Now, if it's brought to our attention and they don't have there's a concern that DPT might apply, but they don't have the relevant sort of facts there, we might ask them to go back and sort of tease out through the regular transfer pricing questions to get some more details about the transaction to see whether DPT could even apply. So the team may be considering it, but we don't want to raise it because we want it. We until we get to a stage where we actually have enough, particularly around the purpose, as Julian mentioned, or some more about the arrangement, whether it's one we want to pursue. We don't want to we don't want to escalate it to a taxpayer to be seen as okay, now we're sort of going to consider DPT, when then we spend 2 weeks looking at it and they give us more information and then we sort of go away. So it's that really fine line between getting enough information to enable us to make a proper sit down as a panel and say, yes, we're comfortable that you now mentioned DPT to a taxpayer as a potential risk and a potential thing we're considering. But at the same time, and the questions, as you've alluded to, they're often very similar questions that we're going to be asking in relation to DPT and transfer pricing. So the information they're already asking for transfer pricing is probably going to be sufficient for us to get there, maybe not on purpose, but on other aspects. So we will send a taxpayer away, a team away to get more information from a taxpayer, not under the guise of DPT, just so that we don't start raising DPT too early. But at the same time, we will start to consider DPT internally to see whether it's potentially applicable before we actually tell a taxpayer that we are looking at DPT. But the expectation is that we will have enough information to then make a decision to escalate to a taxpayer. And we're very clear in our wording when we do discuss it with the taxpayer exactly what it is. This concern really stems from the UK, where the UK is a very different law. It enables them to turn up and say, and if ever you've dealt with the UK on this, here's our transfer pricing, here's DPT, here's a bunch of things, pick which stick you want to be hit with. And we don't have that. Our law's different to that, and so we're not trying to do that. We're not trying to put DPT on the table too early to force that settlement on transfer pricing. So it is that sort of fine line. We need enough information to actually think that DPT is applicable and should be raised, but at the same time, we don't want to sit there and be telling taxpayers that we are considering DPT too early.
Okay, so the reality is, though, that a DPT analysis, proper analysis, a taxpayer should be aware of that taking place because it would have gone through your team.
Correct, yes.
And on the UK point, that's true, but we have a lower threshold. So the horses get spooked a lot easier in Australia just because of the 80% and their rate compared to ours. So yes, we've got a different notification process, but we've got a lot more taxpayers in the net, potentially in the net in Australia than you do in the UK.
Sure.
I would say.
So yeah, just to confirm on Michelle's point, that a taxpayer will be informed that we are considering DPT, and then we would actually go down the path even before we're taking it to initial GAR, even before Deputy Commissioner sign-off, even before escalation. I mean, there is always that little asterisk caveat that if we're concerned that someone's going to phoenix a structure or abscond, my TPG style, that we want to make sure that we can issue.
We don't support them.
No. I'm just bringing up ones that we've been burnt in the past, that we turn up a week after the transaction and money's gone, so we don't want that, obviously. No. But they're the only ones that we've got that little caveat in our PSLA. They're the only ones we really envisaged to be that kind of scenario. The rest of the time, we would expect to, and we telling our case teams they have to speak to us first, and we review the letters before it goes out, so that we're not, again, it is really showing what we're doing for DPT, and then it goes through that full process, and there's no time requirement on us by the time we notify a taxpayer that we're considering DPT and when we will take it to initial GAR. So if we're going down the path and we can hopefully get this solved and we don't want to go to a GAR panel, we don't issue DPT, this may go on for a while if we can get a solution that everybody's happy with. So it doesn't start a clock. There's no requirement once the DPT specialist team has said yes, DPT is potentially something to consider, they have to then take it. If they can solve this matter and DPT goes away, great. If not, we've got the other processes there to ensure that it's only then used once Deputy Commissioner sign off on it.
Okay.
Yeah, I'd probably add to that, and it goes back to Anthony, something that you said about your expectation would be generally that before the DPT was looked at, we'd have to be fairly far down the transfer pricing road in terms of having a kind of intractable dispute. And I'd probably just want to clarify that our view is not that the application of the transfer pricing rules have to be somehow frustrated, or we have to have reached some kind of stalemate before we can go to the DPT. So if a case looks as though it's a DPT case and it's got all the hallmarks of a DPT case, then it's just as likely that would be identified early, and we'd run a DPT review in conjunction with a TP review.
That to me, whilst I understand it, seems inconsistent with a fairly clear paragraph in the explanatory memorandum, which certainly indicated that the expectation would be that the ordinary TP rules would be given consideration first. Now, depends what you're talking about in evasion type cases or things that are just so clear that normal TP wasn't going to cut it. I get it, but and you mentioned as an example earlier reconstruction cases. So the reality is the new 815B, which isn't so new anymore, has got fairly strong provisions in there about reconstruction. And so I guess as a taxpayer or an advisor, you're sort of saying, well, at what point should it be a dispute that we could be considering reconstruction under 815B, or something the ATO would prefer to apply DPT on? And so, again, from a large corporate's perspective, it's really hard to work out where this is going to go. And there's some really practical issues that big corporates need to think about, not the least of which is their internal upward management to executives about something that's an anti-avoidance challenge versus something that's plain old transfer pricing that I think a CEO and a CFO and even boards would understand that there's a fair bit of grey in transfer pricing. You may have a dialogue with tax authorities on that. And so, again, it makes it hard to work out where the delineation is between transfer pricing and DPT, particularly when you start thinking about reconstruction, because the new TP provisions do have specific rules on that.
Yeah, so I'd probably go back to what I said earlier, and the point at which we really think the distinction lies is probably the principal purpose test. Just in relation to the comments in the explanatory memorandum also, I think a lot of this debate arises from the fact that we're perhaps reading those paragraphs of the EM a bit differently. So I think what the EM says is that the DPT is not a provision of last resort. However, the expectation is that ordinarily the other provisions of the Act will be considered before the DPT is applied. So I think the way that we read that is to say that really that means that we won't issue a DPT assessment until we've considered the other provisions of the Act. It doesn't mean that we have to have finalised all other avenues before we can even start to consider the DPT. So that's probably where the difference lies. And
people understand that. I guess the question that people still have is to understand, well, when is it going to start this DPT discussion? Because there are lots of just TP disputes, and they're all about the normal TP things: functions, assets, risk, pricing. And I guess taxpayers have an expectation that there'll be a level of due process, on such a transfer pricing dispute before, as you said, the big stick comes out, which is the threat of diverted profits tax, which will, as I said, have certain ramifications internally for companies and their advisors.
I'm just mindful of time, but I think it's just to wrap up this particular point, and I won't tell you how many times I've had this particular discussion, but my observation from being involved with the DPT from when it was a twinkle in the Treasurer's eye is that there is space between Treasury's view of the object of DPT, tax officer's view, and the external view. And I think we are still grappling with how to bridge those gaps. And I suspect we're going to be having more of these conversations as time goes on, but that's probably an observation to leave people with as we move on to another point.
Yeah, well, look, Michelle, that's probably a fair observation. The one thing just before we move on that I will mention, I think you asked a question going back a few minutes about the constitution of the GAR Panel.
Yep.
And whether, because we've got this sufficient economic substance test, which has these transfer pricing concepts, the panel would be constituted differently to what it ordinarily is. And the answer to that is no, it won't. It'll be the ordinary Part 4A GAR panel. The one thing I can say about the panel though is that they do know about transfer pricing, and you know, it seems that when you go up to the panel, sometimes they're interested in everything but the application of Part 4A. So they're you know, they're very used to dealing with transfer pricing issues.
Right. Well, they'll be getting very used to that, I suspect.
Maybe a point that we can all jump to is talking a little bit about the sufficient economic substance test, because for most of the people in this room and listening in big corporate land, when you go through the three main exclusions, the 25 million of income, well, that's not really relevant. Sufficient foreign tax, again, with everyone dropping their tax rates around us, it's harder and harder to ever get into that exclusion. So the main out, and again, for all the reasons we talked about with the primary purpose test being a reasonably low bar, or at least that's how people are reading it, the main way that people are going to get out of the deferred profits tax is by passing the sufficient economic substance test. And I guess you made some good points about how it links to normal transfer pricing concepts, and I think again the EM and even the Act sort of point you in that direction. We're talking about functions, assets, risks. We're having to consider the OECD transfer pricing guidelines. But I guess the thought that keeps coming back to my mind is, if you're in a deep transfer pricing dispute with the ATO, by definition you're effectively having an argument about functions, assets, risks and pricing. And I grapple with understanding how it would be that the ATO would say, yes, in our transfer pricing dispute with this taxpayer, we're fighting you about functions, assets, risks and pricing. But on the other hand, when we look at the exclusion from diverted profits tax being the sufficient economic substance test, we accept that you've got sufficient functions, assets and risks, and they're all appropriate. So again, it's a practical matter, is when's the ATO ever going to say, oh, well, yep, we'll continue fighting you on transfer pricing, but you've definitely met that test of sufficient economic substance. I just can't see that happening, and that gives me some concern when it's the main out for the big corporates on the assumption that they've tripped over primary purpose. Yeah,
sure. So I think whatever the precise legal boundaries are of the test, I think I said there was, you know, there's probably some debate as to whether it's strictly transfer pricing or something else, and we won't really know the answer to that for some time, I expect. But whatever the answer is, it's fairly close to transfer pricing. I think that means that at a practical level, you're right, it's difficult to see that we would ever accept that you've satisfied the SAS test in a situation where we still believe your transfer pricing's wrong.
Yeah.
So to answer your question, I don't think you can satisfy the test, at least as far as we're concerned, if there's still a significant pricing dispute. And I think that probably goes to the point of one of the objects of the DPT being to encourage the more timely resolution of disputes. That probably the best way to satisfy the SAS test and indeed get rid of a DPT case altogether is to satisfy us that your transfer pricing is right.
I mean, I think there'll be a lot of people quite concerned about that comment because, as I said, it is the main out for large corporates, and there are lots of genuine transfer pricing disputes going on for all the reasons we understand, and people just want comfort that, hey, mine's just a transfer pricing dispute. We understand that you can have different views on functions, assets and risks, but we don't really want to be considering this anti-avoidance stuff. And I think it goes back to some of the dialogue earlier about, well, the primary purpose test, I think what you're saying is probably not as low as the advisor community and the corporate community perhaps think. But I think everyone will be very concerned at what we just heard then about it being something that you'll never pass if you're in a very big TP dispute over pricing.
Just have a question in the audience here.
Greg Layden from ExxonMobil. So is the reverse true then, that if your transfer pricing is right, then your DPT should also be right, or you should otherwise satisfy the SES?
Generally, although not always. So I say generally because if you have a transfer pricing dispute and the DPT, I suppose, is being used as a mechanism to try and resolve that dispute. So in other words, if the only thing that we're really concerned about is transfer pricing, then the answer is yes. If you satisfy us that your transfer pricing's right, or we reach an agreement on transfer pricing, then the answer is that the DPT won't apply. It will be off the table. It will have served its purpose. I do, however, have to qualify that in one respect, which is that you can actually have a DPT case that has nothing to do with transfer pricing. And the reason for that is that the transfer pricing rules look at conditions that operate between entities where one of the entities has what I'll call a connection to Australia and the other is an offshore entity. Whereas the SAS test, you have to demonstrate that the profit made by each entity in the scheme reasonably reflects the economic substance of the entity's activities in connection with the scheme. So that can be an entity that has no relevant connection with Australia. So in other words, you can have a situation where your transfer pricing is right, but you still fail the SAS test because you've got an SAS problem offshore. But to kind of wrap that up in a bow, that's not really going to be an issue in the kind of case that I think you're talking about, because I think you're saying when we're looking at the DPT in relation to a transfer pricing case, will we have a DPT problem if we demonstrate that our pricing is right? And the answer to that is no, you won't.
So just to jump in, aside from those tax benefits that don't relate to price, so withholding tax avoidance, R&D, phytos and exploration credits, now those last three, if you can come up with a structure to avoid those that DPT can apply to, I'd love to hear it, but really withholding tax. So think about...
We'll do our best, Nick.
Do your best, great. Really looking at, say, your traditional treaty shopping, you can arrive at a situation where your transfer pricing is correct, but you still have a withholding tax benefit that you've entered into to do it. Now, if you do have sufficient economic substance through the rest of your every entity connected with the scheme, then you still could get there. But there are going to be some DPT that, just to round it out, I know that's not the key point, but just for clarity, there are some DPT benefits that don't relate to sort of have any overlap with
So just,
transfer pricing.
can I just pick up on that point about every entity has to have the right level of profit, functions, assets, risks, etc. From a practical perspective, is the ATO not practically going to say, let's look at Australia and let's look at the rest of the world? Because if there's some disconnect between two foreign entities, what does it matter? Because it's sort of just really, it's all offshore.
Sure. Thanks, Anthony. So in that instance, then we would look to try and get you out of DPT through more of the tax benefit side. So if you say, well, my transfer pricing's fine between Australia and the next level, the rest of the scheme has got problems for substance because I put all my profit in one of my foreign entities, not one of my others, so I can't get there on substance. Then we'd look at saying, well, if the Australia price to the next level is still appropriate and correct, could we argue then that you don't have a tax benefit because your counterfactual is that you would have paid exactly the same from another related party or something else there? Yep. Then that's the avenue we'd go down.
There's no tax there.
So yeah, there would be scenarios where your transfer pricing we're all comfortable with and you won't have tax benefits, DPT doesn't apply. But if we did unpack all the entities in the scheme, we would potentially identify one that doesn't have sufficient economic substance so that the test can be met. But in that instance, we just look at tax benefits. So without a specific fact pattern, I'm not sure if there could be others that fall out, but that's where we'd look to.
Yeah.
Okay. I've got a nice, easy technical question here online. Please confirm if the overseas counterparty is in tax losses and hence no tax is payable, the sufficient foreign tax test is not satisfied, resulting in the DPT applying.
Thanks. So yeah, short answer is that's correct. Yes, sufficient foreign tax would not be met. It's actually a liability tax. So if there are losses overseas and no tax is paid, then sufficient foreign tax will be met. So there are two scenarios that could result. There could have already been losses there, and in that situation, you've entered into a scheme to essentially move your profit to an entity that has losses, which case then DPT may be something that would be considered. Where, however, you'd originally entered into an arrangement with an overseas entity and it had made losses, for instance, in relation to another avenue part of its business that had nothing to do with the scheme, and therefore you went and no longer had sufficient foreign tax, then you'd have to just look at purpose of why you entered into the scheme and say that we never, there was always the intention there to. Okay. So it is liability to pay rather than the headline rate, and losses are taken into account.
Yep. Just continuing on the sufficient economic substance discussion, I've had trouble wrapping my head around how you might apply that exclusion to financing arrangements. So financing to me is something that's a lot easier to think about just from normal transfer pricing perspective, but in what, have you guys given much thought yet to how the tests could apply, or even DPT at all applying to financing, where it's just, the pricing might not be what you want?
Sure. So, we hadn't focused on sufficient economic substance for financing, given the thin capitalisation modification meant that we focused on other areas that we wanted to provide more certainty. With a financing entity, again, it will come down to what it's doing. So a plain vanilla financing we would find is covered by the thin cap modification, and potentially SES is not where you'd want to look. Where there are other arrangements involved, derivatives or other scenarios that you've involved, we could consider if that's something that whether or not we need to include an example on what is substance for a financing entity, a treasury function, and the kind of things we'd look to. So
I think the example I was thinking of is the level of debts within a taxpayer's thin cap ratio, but the ATO and the taxpayer have got a disagreement as to what the pricing of that should be. Again, I see that as purely sitting into plain old transfer pricing dispute territory, but in what circumstances could you see that falling into diverted profit tax territory?
Yeah.
Well,
Throw you under the bus.
look, I think if it's a really ordinary case like that where the taxpayer's being charged 6% interest and we think it should be 4%, then it's not going to be a DPT case full stop, because that's what I'll call a pure pricing dispute, and that's not something that is confined to financing. I think if you've got an Australian entity that's buying sneakers from its offshore related party, and they're paying $100 a pop, but the tax office thinks it should be $80, then again it's a plain transfer pricing dispute, and it's not the kind of case to which the DPT would apply. So again, I probably sound like a broken record here, but really the point at which the DPT comes into play is if there's something about the scheme that is, to use the old Part 4A language loosely, artificial or contrived, that suggests that objectively there may be a purpose of obtaining a tax benefit, and that's not something you'd get where you're doing something that is pretty straightforward and there's just a pricing dispute.
No, I'm good.
We've got about 10 minutes to go. Maybe jumping to a separate topic, and that's about MAP in treaties. So because the DPT has been dropped into Part 4A, on the face of it you can't get access to the dispute mechanisms in the treaties, at least as currently written. I guess the question I had is DPT is a little bit different to some of the other Part 4A stuff, in that DPT is running in parallel usually with the transfer pricing dispute, and the way that you can make a DPT assessment go away is for there not to be a tax benefit, and that would be to self-assess your transfer pricing position. So again, using the example we used before on the financing, if there was a dispute, whether it's 4 or 6%, the taxpayer may go to what the ATO thinks it is, make their assessment. I guess the first question is does the DPT assessment definitely fall away because there's no tax benefit? And the second question is I would have thought once a taxpayer's done that, they then have access to MAP over a transfer pricing dispute, because they can object against the position they've taken and take that through a MAP process, even though it started as a DPT assessment. But I know you haven't issued any assessments yet, but has that been thought through in the ATO?
Sure. So thanks, Anthony. We had a little bit of thinking on this when we're considering for the MLI and matters that will go to arbitration.
Yep.
So we spoke to the MAP team to consider, have they seen any cases where people have deliberately amended and transfer pricing to get into a dispute to avoid the application of, say, Part 4A, and they couldn't think of any to date. So they were going away to sort of revisit some of the historic ones to see if that's the case. So we haven't actually had to consider whether in that scenario of avoiding an anti-avoidance provision by self-assessing and getting in it as a very crude way of describing it. So they hadn't really considered that aspect, which means they hadn't considered whether or not they would refuse that taxpayer access to MAP. We generally, so we haven't had to consider in the past whether we let people in. The MAP, international MAP provisions, so not our domestic ones, but international MAP provisions do suggest that revenue authorities not let people in a MAP where where it's an underlying anti-avoidance dispute that they're going to. So we haven't had to consider it. So I don't have a firm answer on this because it hasn't been something we've considered in the past. But we have approached our MAP team. This is more for the MLI because once you're in MAP after 2 years or 3 years in Francis' case, you can go to arbitration. So we sort of are examining whether that has been the case in the past. But we haven't seen it, so we haven't really had to consider whether that's something that we would entertain or reject. Now, if someone self-assesses and they're getting hit with double tax, which is what MAP's trying to stop, then of course we want to help them as much as possible to get the outcome that's right. But take an extreme version of what you described, where people are purely doing this to avoid DPT and then getting the adjustment back down under MAP or under arbitration, we'd have to consider whether that's the appropriate use of MAP. But we haven't had to consider it in the past.
And I don't think anyone's done too much work on it yet in terms of really technical position. But I guess what a corporate or a tax advisor might say is, well, this actually, despite it ended up into DPT territory, it started out as just a genuine transfer pricing dispute. It ended up in there because of all the reasons we talked about, low thresholds, and it's hard to meet the exclusions, etc. And so most taxpayers are still looking at their dispute as it's a transfer pricing dispute. The fact that the ATO's called it something different, I suspect when you talk to a board or a CEO or a CFO, they'd be saying, oh yeah, we've got this big transfer pricing dispute. They won't really understand the intricacies of what you just explained. And so I think that's why there'll be a lack of understanding if it were the case that the ATO said, well, no, you can't access MAP even though you've paid your tax, and there's still that underlying TP dispute because the parties still don't agree.
Yeah, I'd just probably make the observation about this that the same kind of thing sometimes happens in ordinary income tax cases where taxpayers self-assess and then we call it a self-objection. And the observation I'd make about it is that it never goes down very well. There are one or two practitioners in particular who somehow think that it's clever, but in my experience, it just tends to get some deputy commissioners within the tax office pretty stroppy, and the taxpayer ends up getting basically put into really quite intense audits, albeit under the wider objection framework. So it doesn't actually seem to solve anything.
And I guess the only difference here is it's a pretty serious process when you get into MAP with another country, another tax authority.
Exactly.
So I get your example, whether it would be the same approach for something where it's an international dispute. I'm not sure.
Just down to our last couple of minutes, Anthony. Do you have any final observations, questions for the tax office?
Probably just an observation. I think there's still, both in the advisor and the corporate community, a lack of understanding of where the delineation is. I think they're probably, from this discussion, I think there's a few things that probably have come out of it which would indicate maybe there's more guidance, whilst you've already done a pretty good job on getting guidance out reasonably quickly. I think some more guidance around the primary purpose test would be something that would help taxpayers, particularly given what we heard about the difficulty in meeting the sufficient economic substance test.
So just in conclusion, Nick, can I confirm, when would the earliest, given you've got a July 2017 start date, when's the earliest you're likely to see DPT action in Australia, given it's a post-assessment?
So post-assessment would be the first tax returns will be lodged 15 January 19.
That's right.
So, and like I say, that's the minority of taxpayers are in that balance period. So then it would have to be identified for audit. Our processes obviously will need to identify to audit, sent to an audit team and taken through. So from post-lodgement, it is likely to be a while away. The pre-lodgement, so your APA ruling process, we are considering DPT now because it is part of our APA and the sign-off we're given for APA.
Yep.
So there are some taxpayers that have considered it and it's in their APAs, and we've signed APAs to date that do say that DPT will not be issued. So it's not that we're issuing DPT assessment, that we're actually signing off to say there's no DPT, but the first DPT assessment, I mean, if we got, heaven forbid, but if we were concerned about a Phoenix structure and had to issue DPT assessment, the first we could do is 16 January next year, but really that's incredibly unlikely.
We're going to miss your holiday this year.
Yeah, exactly.
That's right. That's right.
Yeah.
And I think it's just a good point to note, because we are live in terms of, as you say, preventative measures, but we're still some way away from DPT assessments, and I think it is worth reiterating the point that the ATO all the way up the chain have been very clear about DPT assessments only being issued in the most exceptional of circumstances. Some of the stats that have come out of the UK, who are a couple of years ahead of us, I think theirs came in maybe April 2015, I think. I don't know. Anyway, they had the bright idea first, let's just say that. And the stats coming out of the UK are quite interesting in terms of the revenue being generated by the DPT. The confusion there obviously is their DPT and Maley, one in the, well, there's two limbs of the same provision, but it seems most of the money in revenue coming into the UK from those provisions has come from their equivalent of the Maley. Very little has come from the DPT. The expectation is the same in Australia. Obviously the CTA's approach, and Nick and Julian will continue to be very sick of me and members, is to ensure that long and involved stage before assessment, that taxpayers still feel confident to have robust TP disputes and other disputes with the tax office without a provision as draconian as this one being applied as leverage, and that will continue to be a discussion, I think, as we work through towards 2019. I also think people should be very aware of the practice statement guidelines around, as Nick was talking about, the need to raise a DPT analysis with his team, and the fact that taxpayers should be made aware once the ATO has got to that point where they are actually making officially sort of embarking on a DPT analysis. I would also say, just in closing, that given we're only the second country in the world to enter into a DPT, this is a global interest both administratively and academically, so we expect these conversations to continue. Certainly encourage our members, and I've promised Mark Conser that if I hear any DPT whispers before they should be whispered, that we will let him know immediately. So call out to everybody across Australia who's watching this, and I think we all want it to be applied appropriately, and for the provision to not unnecessarily disrupt business as usual. So on that note, I just wanted to thank our panel, Nick, Julian and Anthony, and thank you everyone for coming, and have a great afternoon. Thank you.